started. My name is Duell Ross. I'm the Vice President of the Black Law Student Association here at Penn Law. This is the first of a hopefully monthly Civil Rights Speaker Series named after Sadie Alexander. The reason why we're doing this Sadie Alexander Civil Rights Speaker Series is because over the last 20 years or so, BALSA has been doing a conference to raise money to have a civil rights chair here at Penn Law. And we're getting closer and closer to making that a reality. And so to celebrate that and to kind of bring professors who we'd like to see at Penn or professors like them at Penn, we decided to do this monthly series over this semester and possibly into next semester. So we invited Professor James Forman, Jr. of Georgetown Law. He, as I'm sure some of you have read, he's an expert in criminal and education law. He's had a wide range of professional experiences. He worked as a public defender in Washington, D.C. He started the Maya Angelou Charter School to help juveniles who've been kicked out or had troubles in other schools. And he also clerked for Sandra Day O'Connor, for all you kids interested in clerking. So without further ado, please welcome him.
Thanks for having me. I'm pretty convinced that despite all the efforts of folks here to make it work, there's some technological thing that I'm not going to be able to do at some point. And so we have assistance when that happens. Thanks, Duell, and thanks to the Black Law Students Association here at Penn. I really appreciate it. The chance to come. I know you all are working hard on a bunch of projects, and I think the one thing that I'll tell you from my own experience of having been an activist law student is that there are things that you put in motion when you're in school that you don't actually see the results of until after you've left, and you may never see the results of them yourselves. But they're still valuable things to the institution, and I see that now. Certainly at Georgetown, there are things that students get very active about, and it takes universities a long time sometimes to move, but then things do happen after the students have left, and it was only their work that made it possible. So, so think about that. I'm going to sort of present what's very much a work in progress for me, and I'm really hoping to get sort of your comments and feedback and questions. This is a project that I've just started thinking about, and it's, I think, going to grow into a larger project. So, if you've been reading the paper or looking at the television, you see that for opponents of how the Bush administration has prosecuted the war on terror, there's a certain euphoria in the air. Rachel Maddow, the liberal host of MSNBC, an evening show on MSNBC, is giddy every night. And former critics of the Bush administration in the legal academy are now knocking on the doors of the Department of Justice, the Office of Legal Counsel, the White House counsel's office looking for work, and in many cases getting it. And the euphoria is based on a pretty straightforward narrative that's taken root in the past few years, which goes something like this. America has a long-standing and deep-rooted commitment to human rights and due process, which is reflected in the procedural protections of our domestic criminal justice system. After September 11th, President Bush, Vice President Cheney, Secretary Rumsfeld, and their allies dishonored that tradition. And now we are told that change is in the air, and nowhere more so than with respect to the rule of law and the war on terror. And I want to suggest for a moment in this talk that we look more carefully at what the Bush administration did in fighting the war on terror, as well as the rhetoric that surrounded their prosecution of the war. And if we do that, I'm going to argue, we'll see some connections between the war on terror and the war on crime. And my argument is that in important respects, our approach to the war on terror is an extension, sometimes a grotesque one, but an extension nonetheless, of what we've done in the name of the war on crime. And my argument involves a claim, a certain claim of causation, but it's a subtle one. Specifically, I'm arguing that in pursuing certain policies domestically, we have rendered thinkable what would otherwise have been unthinkable. And second, and related, I'm making an argument that it's an argument about rhetoric. And it's an argument that suggests that the approach to how we fought the war on crime, that in how we fought the war on crime, we've taken a rhetorical position that works in tandem with the policies to desensitize us to harsh treatment of criminals. And this sustained harsh treatment, the sustained punitiveness over time, whether it takes the form of draconian sentences, inadequate lawyers, or structurally abusive prisons, has an influence in two ways. One, the sustained exposure to the harshness combined with the punitive rhetoric causes us over time to see the harshness as an unfortunate but inevitable cost or casualty of war, whether it's on crime, drugs, or terror. And over time, it does something even more than that. We no longer see the harshness as harshness at all. Instead, it becomes what David Garland at NYU has called taken for granted features of contemporary crime policy. So today I want to look at kind of 5 areas in which our domestic criminal system has laid the groundwork for our approach to the war on drugs. So I want to talk a little bit about the scope of our prison complex, prison conditions and prisoner abuse, the growth of executive power, and undermining defense counsel. And then, time permitting, I'm going to discuss the Innocence Movement, which I will argue has tempered somewhat both the prosecution of both the wars on crime and terror. So before I say any more, I want to contrast my approach, my sort of thesis of exporting harshness to some other explanations that people have given to explain what has happened in the war on terror. So the principal explanation that you hear is this idea of wartime overreaction. And this is a basic idea which I think has force, which is that civil liberties always suffer in times of war. And then a closely related argument that I think we've heard a lot is basically, what I'm calling shorthand is blame Bush and Rove. And the argument there that some make is, well, yeah, sure, wartime overreaction is right, but the fear generated by September 11th, some people say, has been stoked by the Bush administration to bully opponents and win support for their measures. So that's the second thesis is out there. And a third one is David Cole's thesis of enemy aliens. And Cole says, look, aliens are always the first target in times of crisis. The government gets to do what it wants when what it's doing is directed at foreigners or the foreign among us who are politically weak. And Americans haven't sufficiently, he says, internalized the costs of the war. So I think there's some truth to all of those explanations. What I'm doing today is not rebutting any one of them necessarily. I'm offering my ideas as an addition to rather than a rejection of some of those. And I do want to offer sort of 2 caveats. First of all, I'm going to draw some analogies between tactics, practices, and rhetoric adopted in the war on crime with those employed in the war on terror. But I'm not arguing by any stretch that there's a jot-for-jot parallel between how we've prosecuted the 2 wars. Some enormous differences exist. Some of the big ones, right? Secret prisons for terror suspects, indefinite detention without trial of the accused, systematic use of physical brutality as a means of interrogation, right? These things mark the war on terror, but they're largely unknown to our domestic criminal system today. Second, I want to say, when I discuss things like conditions of confinement or right to counsel, I'm not saying that our domestic prisons are as bad as Abu Ghraib, for example, or that we deny lawyers to people domestically in the same way that we did at Guantanamo. My argument, I hope, is more nuanced than that. I want it to be anyway. So I'm interested in exploring continuities in places where the prevailing wisdom has been to emphasize discontinuity. I want to understand, in essence, sort of how it came to this, and how we, as a nation, have allowed things to continue even as we've started to learn about them. Even as the truth has begun to surface, in many instances, we have still allowed it to go on. And I think to do that, we need to pay attention to what we do at home. All right. So a few words on the scope of the prison complex. All right. So the first thing to understand, I'm not going to be long on this because I think you all likely understand this. So we have the largest prison system and the highest rates of incarceration in the world by a wide margin. We house 25% of the world's inmates, even though we're only 5% of the world population. And never before in history has a country, a free country, locked up such a high percentage of its citizens. And to get a sense of how much of an outlier we are, I thought it might be useful to compare our incarceration rates to countries that are similarly wealthy. So this is just sort of against a whole range of countries, basically all a representative sampling of the ones that I could find data for. But the next slide, hopefully, okay, so this I think is sort of an interesting way of thinking about it that's a little bit different from how we've talked about it. So this is countries grouped. They're in the same order. They're the same countries in the same order, but now they're grouped according to relative wealth as measured by GDP per capita. So countries with similar wealth levels to the United States are bolded dark, and the other countries have lighter colored bars. And so as you can see, relatively wealthy countries such as France and Italy and the rest of them have low incarceration rates. And that's what most criminologists would predict. So most criminologists would say that the countries that are black, the wealthy countries, are going to have the lower incarceration rates. On the theory that wealthier countries are better able to make the human capital investments that allow for reduced dependency on incarceration. So, and that explains everybody in the world except for us. One of the world's wealthiest countries is obviously there on the far left of the graph, and that's us. Now, just a couple more points on this. It is very true that the United States is a violent country, and there's a big debate among criminologists about the relationship between crime and incarceration rates, and there's arguments that go in all directions, including some new recent research which attempts to make the argument that high incarceration rates actually produce higher crime levels, in addition to being a reflection of them. The only point that I want to make about this, for the purposes of this talk, is that our incarceration rates have increased largely independent of crime. That is to say, so for most of the country's history up until the 1970s, incarceration rates were relatively stable. They were about 110. So we're at about 700 per 100,000. They're about 110 per 100,000 in the United States. But what happened was, starting in 1973, basically, they started to go up, and that coincided with the rise of crime. But since the 1980s, as crime has gone down, the incarceration rates have continued to go up. So we have incarceration rates going up when crime rises. We have incarceration rates going up when crime declines. And again, there's a whole literature about that. I'm not going to get into it for the purposes of this talk. I just want to sketch broadly. Now, there is a debate about the extent to which the incarceration rates reflect the attitudes of the public. Are these an accurate reflection of the attitudes of the public? I'm not going to spend too much time on that today. I do want to sort of give one perspective on this. It's an anecdote more than it is data, but it always sticks with me, which is every year in my criminal procedure class I show a film called Snitch. which is a film about our nation's drug laws and the role of informant testimony. And the film ends with the story of Clarence Aaron, who's like this 20-year-old kid from Mobile, Alabama, and he's tried for driving some drugs from Alabama to Louisiana. Because of conspiracy laws, he's even though he has no priors, because of the amount that was involved, he was found guilty. And because of the amount, he was sentenced to life. And the film ends with the juror, one of the jurors that was on the case, being interviewed. And you have on one shot, you have the camera sitting at Clarence Aaron. He's serving 3 life sentences. And then they're interviewing this juror, and they're asking him about the case. And then they ask him, well, what kind of time do you think he would have got? And the juror said, I don't know, a few years. And then the filmmaker tells the juror that Clarence Aaron has received 3 life sentences. And the juror is visibly dismayed. And we're left with this vision of Aaron sitting there and the juror saying, oh no, that doesn't seem right. Now, there is some evidence that juror's reaction is not unique. That is to say that in drug cases, certainly, our laws are harsher than what the public calls for. But there is contrary evidence on that point. So I don't want to get too deep into that literature. What I want to say for the purposes of this conversation is that the key point is that our prison system's growth is attributable to policy decisions that we've made, how we've chosen to respond to violent and nonviolent crime. I do think it's worth emphasizing, because it gets at my argument about how this has become a part of who we are, that our harshness and our punitiveness has more complicated political and ideological roots, I think, than is typically acknowledged. So the typical account of the political economy of crime policy stresses the role of law and order conservatives, of Republicans trying to create a wedge issue for Democrats, going back to Nixon and George Wallace. But I want to point out how the inclination towards incarceration has actually taken root even in some less likely places. So one good example of this is political scientist Marie Gottschalk has some research looking at domestic violence movements, a movement against domestic violence in the U.S. and abroad. And her findings are interesting. In both Britain and the United States, and throughout Europe and the U.S., the fight against domestic violence grew out of the feminist movement in the 1970s. And in the United States, advocates for battered women ended up turning to the criminal system for solutions and became leading voices for longer prison sentences, mandatory incarceration. By contrast, their allies, their feminist allies in Britain and throughout Europe, were much more likely, it turns out, to focus on social policy, not penal policy, arguing for housing, health services, welfare benefits that they said would allow women to escape from these situations. You also see, in terms of unlikely support for the growth of the prison system, you see civil rights advocates who have shown a similar inclination to seek solutions in criminal prosecution, despite the toll that our nation's high incarceration rates have taken on the African American community. So consider, just as an example, the debate that erupted in response to the aggressive criminal prosecution of black teens in Jena, Louisiana, for fighting with white schoolmates, right? Even as the protesters demanded that prosecutors drop or reduce the charges against the black teens, they simultaneously called for the Department of Justice to bring more criminal prosecutions against the whites for hate crimes. Representative Davis, for example, from Alabama, complained the Department of Justice had charged only 22 people with hate crimes in 2006 compared to 80 people 10 years earlier. And when a prosecutor testified before a congressional panel that the federal law didn't allow for the prosecution of the white juveniles for hanging a noose, he was roundly booed by a room of African American protesters. Unless you think this is limited to the question of hate crimes, I'm also working on a project that grows out of my experience in Washington, D.C., but I think has broader implications. So Washington, D.C. is one of the nation's two largest majority black cities, and has had a black mayor and a black majority city council for many years, and it's overwhelmingly Democratic. Yet the city council and the mayor consistently pass punitive crime measures. The city's sentences are among the longest in the country, and its incarceration rates are among the highest. Well, what's going on here? Well, that's another project, but for now I want to emphasize that the connection between race, crime, and punitiveness in our criminal justice system is more complicated than is traditionally asserted. All right, one more word about race. My larger project looks at the connection between the way race has influenced the prosecutions of both the wars on crime and terror. And I think in both cases, I'm not going to get into too much detail on it, but just to say, we've in both cases, an argument that will be familiar to you all. We've attempted to secure protection for the majority through punitive measures aimed sometimes intentionally and sometimes not at disfavored minorities. The basic idea that won't come as a surprise to a law school audience, but it does bear emphasis that the most punitive or brutal deprivations that have been inflicted in the war on terror have been reserved for Arabs and Muslims. Just as in an earlier era of our country's history, torture, which we don't do anymore in the context of interrogation, but which we once did. And when we did it, it was reserved for black suspects, overwhelmingly reserved for black suspects in southern police stations and prisons. I'm happy to talk more about that, that connection in the question and answer. Okay. Moving on to the question of prison conditions. And how I think they're connected to the argument. So, prison conditions matter. Now, I say that, and you might say, well, that's sort of banal. But I actually don't think it is. Because American lawyers and the legal system has overwhelmingly focused on the time from initial suspicion to final judgment, and has developed an extensive jurisprudence, which we all learn in law school, governing those stages of the process. Indeed, that's the period that most people are talking about when we compliment ourselves on extensive procedural protections in the criminal justice system. But how we treat suspects after conviction has received much less notice. It's ignored in the constitutional and criminal law curriculum of our law schools. It's unfamiliar even to most American criminal lawyers. But those that are actually in the system see the world very differently. And just a story on this, I'll never forget my first visit to a prison to work with somebody on an appeal. It was at Lorton Prison in Virginia, which housed D.C. inmates. And I was armed with my trial transcript. I was prepared to discuss the claims that we were going to press on appeal. And my client interrupted me like 2 minutes into the conversation to say, look, Mr. Forman, I hear that, but my thing is I need to be moved to a different unit. Because I'm in here with all these young guys, and they're just too wild. So, like, can you file a motion or something about that? And he went on to describe the violence of the place, the stabbings, the mayhem caused by inmates, caused by guards. And he was serving a long sentence. And his main goal was to get to a part of the facility that had older, more stable inmates. And basically, my legal claims that I was there prepared to talk about could wait in his mind. And some terror suspects, in fact, it turns out, see the world a similar way. And prison conditions have been a central issue among inmates at Guantanamo. And they've been a key feature of the international condemnation that the war on terror has received, or Guantanamo specifically. Now, human rights lawyers and Europeans have reacted negatively to severe conditions of confinement and prisoner abuse. But Americans have seen it somewhat differently. The Abu Ghraib scandal followed a sort of a typical pattern. You had your burst of outrage and eventual prosecution of a couple low-level officials, and then return to normalcy. As for Guantanamo, I was struck by Amnesty International sought to highlight the problems of Guantanamo Bay. And they wanted to do that last summer by constructing a mock Guantanamo jail cell on the National Mall. So they actually built this thing on the mall. This is not the one they built, but it looked like that. And basically tourists shrugged, like it didn't work. Because we already have 20,000 supermax cells that look just like the cell that they were describing in our domestic prisons. So there's a supermax cell. 23, and in a domestic supermax cell, inmates are 23 hours a day. They get in isolation. They get to go outside also in isolation for 1 hour in a little exercise unit that's attached to the cell. They get a jumpsuit, a t-shirt, boxers. Those things can be taken away. When they refuse to eat, they can be force-fed. And so here's the Guantanamo cell that Amnesty was trying to highlight, and then there's the domestic cell. Of course, some of the units at Guantanamo are very familiar, although there are certain restrictions, like visits that are more severe at Guantanamo Bay than they are in the domestic system. Although domestic prisoners are shipped all around the country, so often they can technically have visits, but they can't, in fact, have family go across the country to see them. So now, domestically, conditions are better outside of supermax facilities than inside, but not always. So here's a photo of a Phoenix jail in which prisoners are housed in tents, even in heat above 100 degrees. And it came to mind when somebody first sent me a photo of prisoners housed at Bagram Air Force Base in Afghanistan. I said, wait a minute, I've seen a photo that looks like that, and it was from the Phoenix jail. There's also another thing, which is this is beyond in terms of prisoner abuse. This is beyond my area of expertise, but I wish somebody would write about it, or maybe somebody has, and I don't know about it. But a common theme, both domestically and in the context of the war on terror, that you sometimes see involves some sort of feminization. So you have a sheriff in Arizona who prides himself on dressing his inmates in pink and calling them sissies, and when he puts them on a chain gang. You have a sheriff in North Carolina who paints all of his cells pink and calls his inmates women. And then, of course, you'll remember some of the photos from Abu Ghraib, and I've picked, obviously, a non-shocking one this was one that involved one of the female guards' underwear on a prisoner. So then you have the question of dogs. So you remember probably this sort of outrage at all of these photos of the barking dogs sicked on prisoners. Domestically, dogs have been used as a form of inmate control for many years. So one final point about the connection between our domestic criminal system in terms of prisoner treatment and the war on terror. So till now, my argument has focused on kind of patterns of behavior that cause us to get accustomed to a level of harshness so that we don't notice it. Or when we see it, it doesn't bother us. But with regard to prison conditions, or prisoner treatment, there's actually a more direct connection. So our domestic prison guards are trained and socialized in this punitive environment that I'm describing, and they sometimes export those tactics to the world via the war on terror. And the harshness often circles back to the U.S. domestic system. So just one story, and there's more like this, but one that kind of highlights this cycle is the story of Charles Grainer. So Grainer, name might be familiar, achieved some sort of infamy as the ringleader of the abuse at Abu Ghraib, and he was sentenced actually to 10 years in prison. But before Grainer got to Abu Ghraib, he was a domestic prison guard and a Marine. So he served in the Marines in the 80s and the early 90s. And then upon returning home, he was hired. There's actually an affirmative action program in the Pennsylvania state prison system for ex-military. And so he was hired at the maximum security SCI Green facility. And that facility, while he was working there, was rocked by this massive prison abuse scandal that led to changes in the administration, firing of some of the guards. Grainer wasn't fired, but he was then, after the war in Iraq, he was reactivated. And his prison guard experience, his domestic experience, led him to being placed in a position of authority at Abu Ghraib, and it was that abuse of power that ultimately led to his downfall and his eventual conviction. All right, let me move from kind of the prison conditions and prisoner abuse issue to another area where I think we see some connections between these wars that I want to draw out a little bit. And this concerns the growth of executive power at the expense of kind of judges, right? That's been one of the hallmarks of the past decade. And the growth of executive power at the expense of judges, I think, is connected to, and I think we need to think about how from the launch of the war on crime in the 1970s, judges have come under sustained attack as insufficiently committed to the cause of fighting crime. So these critiques have taken a variety of forms, but judges have been criticized as arbitrary, as irrational, as idiosyncratic, as elitist, as susceptible to being duped by clever defense lawyers. Clever defense lawyers or, especially sympathetic defendants. I just got a little out of order here. But consistent with those criticisms that have been leveled, there have been a series of efforts by legislatures to reduce judges' authority in criminal cases. Right? They've used a variety of mechanisms. Congress has cut back on habeas corpus, limiting prisoners' ability to challenge convictions and conditions of confinement. Judges have lost sentencing authority. So in 1980, there were only 2 states with sentencing guidelines, and by 2000, there were 17. In 1980, no states had 3 strikes laws requiring life sentences. By 2000, 24 states did. And during that same time, mandatory minimum sentences came into effect, and legislatures moved to abolish parole, right? All of which resulted in less authority for judges. And I think that there's sort of a rhetorical piece that accompanied the legislative moves, and that serves as the backdrop, I'm arguing, to the Bush administration's decision in some ways about how to handle those that were captured in the war on terror, right? Because the first thing that the administration did was set up military commissions, not civilian courts, who are going to be manned by judges who we've learned may not protect us from murderers, and we're not going to let them. We're worried that they're not going to protect us from terrorists. And then the Supreme Court said, right, of course, as you all know, the executive can't do that on its own. The administration was forced to seek a legislative approval, which they got through Congress, right? So this is the Military Commissions Act. I think that what you see is you see a parallel between the kind of arguments that are made, that we can't trust these individuals to keep us secure, and then the kind of policies that are put into place, meaning we can't give these judges too much authority because we're afraid of what they're going to do with it. And both domestically in the war on crime, that authority has moved to the executive branch. So it's prosecutors that have gotten the authority that judges have lost. And so too with the war on terror. The authority that judges have lost has gone to the executive. So let me move from that point to something. PowerPoint got out of order somehow. How did that happen? I'm not sure. All right, so I'm going to abandon the PowerPoint and just talk about the question of lawyers. So I want to talk about kind of the role of lawyers, and I want to sort of make this point by talking just briefly about a case that I had right when I got out of law school. It was a case in Utah where a guy was charged with, he was on death row. And the local judge had decided to appoint a defense attorney who was a young guy that had just himself graduated from law school. So this is like 15 years earlier than I'm getting involved in the case. Had never tried a criminal case. So he never tried a criminal case, and now he had a death penalty. Now he was facing the death penalty, or his client. He was representing a client who was facing the death penalty. Well, anyway, maybe the client would have been convicted anyway. But his fate was surely sealed when in one of the most complicated areas of law that we have, and certainly the most complicated in criminal law, he was given a lawyer who had never filed a single criminal motion. Now, as some of you all are learning, in criminal law and criminal procedure, my client's situation is more typical than I knew at the time. So, since about 3/4 of felony defendants are poor enough to receive a state-funded lawyer, American criminal defense, for practical purposes, is the criminal defense of the poor. And it's rare to see the outright denial. We don't see the outright denial of counsel that we see in the Guantanamo context, but we do see a virtual denial. And it seems to me it raises the question of, at what point does policy and practice become law? So at what point are policies and practices such that it's meaningful to say, well, that's in fact what the law is? What I mean by that is, let's look at sort of limiting funding, for example. The United States spends less, for example, about 1/3 per capita of what England spends on its indigent defense system. But in individual states is really where you start to see it. So in Indiana, lawyers are only allowed to bill $150 for a misdemeanor case. That's the maximum they can bill, at $1,250, $1,250 for a felony. There was a New Orleans public defender who reported having more than 400 clients in half of a year. So 400 clients in 6 months. And actually, as a result of cases like that, the Louisiana Supreme Court some years ago basically held its indigent defense system ineffective. But there never ended up being a meaningful remedy for that. And it seems to me that the cases of sleeping lawyers, the cases of drunk lawyers, the public defender with the overwhelmed public defender who just wants to plead out a client, those inadequacies have become well known. Reams of reports have been issued, books have been written, and the public, more or less, it seems to me, responds with a shrug. Or really, I would say, you might say, at best a shrug. Because the last piece of how we think about defense counsel in the context of the war on terror and the war on crime, I think concerns the aggressive anti-defense lawyer rhetoric, which has come to mark our culture. Right? So during the 1990s, federal funding for capital defense lawyers was largely eliminated. And during that time, public defense programs were criticized in, for example, in the Wall Street Journal as, well, taking money away. If you're funding this program, you're taking money away from law-abiding citizens, and you're giving it to murderers, to drug dealers, to illegal aliens, and to delinquent fathers. That's a quote or a paraphrase, but it's almost an exact quote of the claim in the article. Individual lawyers have been attacked for their role. So there was a video that became a big deal in Virginia in 2005 when Tim Kaine, who was running for governor at the time, was attacked for the work he had done as a defense attorney, a court-appointed lawyer, earlier in his career. And the argument was that he had voluntarily represented a murderer. Voluntarily, and the emphasis of the voiceover was on the voluntarily. And that, it was alleged, meant that you couldn't trust him. Deval Patrick, I don't know if any of you all followed any of his run for governor in Massachusetts, but there was a similar ad that he was faced with. You see the same thing going on in the war on terror context. There was sort of a comment that became well known, but actually was not unique. It became well known because it was an actual Pentagon official who said it. But this is the comment of Charles Stimson. Some of you might be familiar with it. But he basically said he was attacking the big law firms that were representing folks at Guantanamo. And he said when the corporate CEOs see that those firms are representing the very terrorists who attacked them and their bottom line on 2001, the CEOs are going to have to make a choice. And they're going to make their law firms choose between either representing us or representing these murderers. Now, that quote became kind of a big deal because he was a Pentagon official. But there's example after example after example of similar arguments that are made and have become part of our discourse at the time. The last thing I'm going to say before I stop and get questions and hopefully have a conversation has to do with the question of innocence. Because to this point, I've sort of focused on some parallels between these two wars, terror and crime, that point towards harshness. But there is one other comparison that sort of pushes back in the other direction, and it's the Innocence Movement. And it's done something to shake the certainty with which our country approached the prosecution of both of those wars. Right? So, not long after Guantanamo Bay originally opened, reports began to emerge that some of the suspects held there were innocent. Now, those reports were initially ridiculed and belittled by Defense Department officials and those in charge of running Guantanamo. And even sometimes in individual cases, I mean, Clive Stafford Smith writes, a lawyer representing some folks in Guantanamo, has a videotape of his clients, in where they live when they're supposed to have been committing these, being involved in terrorism, and the government still sort of denied that for 2 years before eventually releasing them. That response to individual claims of innocence is familiar to those that litigate in the domestic criminal system. I worked on a case sort of at the very end of the case, but a case out of Memphis where that ended up being on Nightline. It was my colleague Laura Hankins who litigated it, and it was a case of ineffective lawyering at trial, which she eventually got on appeal, and the end result was receipts from a store that the clients had at the time of the murder. showing that they were shopping in this particular mall. And, of course, their lawyer didn't think this was important because the lawyer had, 1,000 cases and was making, $500 maximum and just wanted to plead the client out. But sort of, in a way, more shocking than that, because, I was mad at the lawyer. But more shocking than that is a government's response, because the government fought for years and years and years, even in the face of this evidence, before Nightline and everything else, and eventually resolved the case. It does seem to me worth thinking about in both when we look at Supreme Court rulings in this area, asking the question to what extent this innocence movement, which played itself out in the domestic context, it's been the most kind of powerful response to the war on crime, and it played itself out in the Guantanamo context, because report after report after report would get released, showing more and more of the people there innocent. I think it's an interesting question to sort of think about how that might have affected Supreme Court decisions in this area. This is obviously a perilous sort of way to speculate. But if you look, for example, at Justice O'Connor's jurisprudence, she was a long-time supporter of the death penalty. She was the swing vote as the conservative justice in a number of death penalty cases. In 1989, for example, she wrote the majority opinion saying that a mentally retarded murderer with the reasoning capacity of a 7-year-old could be executed. But by 2002, she had reversed her view, and she had joined 5 other justices in saying you couldn't have the death penalty for the mentally retarded. And in between those decisions was the Innocence Movement, and were a number of speeches in which she gave, and she started talking about, in some of her speeches, in particular a big one in 2001, where she talked about the statistical evidence suggesting that this system may be allowing innocent people to be executed. And she said there's a serious question being raised about the death penalty in this country, citing to the innocence evidence. And then she changed her mind about whether mentally retarded people, whether it was constitutional to execute them. She also, in that speech, talked about the quality of lawyering. Justice Kennedy, similar. So he's obviously the key vote in some of the current, including the Boumediene case. In between his votes in a couple of the domestic criminal cases, he starts to cite the inadequacies of the criminal justice system and the Innocence Movement. And again, prior to his votes in Boumediene, some reports started to come out suggesting staggering numbers of innocent people held at Guantanamo. Was he influenced by that? We won't know until people are years from now and they're able to get into his notes. But it is interesting how non-deferential he was to the government, to the executive branch, which was arguing we know best in light of these evidence that maybe the executive branch was wrong in a lot of its judgments. So it seems to me that, of course, with Justice Kennedy given his influence, it's going to be important to keep watching what he does in this area.